Hi, Sanjana. Yeah, just go ahead. Hi, Sanjana. Yeah, just go ahead.
Hello, Ms. Kennedy.
Hi,
Are you able
Sanjana.
to hear me?
Yeah, just go ahead. Yeah, just go ahead.
Hello, everyone. Thank you for joining us today. I'm Sanjana from the Law Offices of Mary Kennedy, and I'll be your host for the session. We're going to talk about a major policy
Sanjana from the Law Offices of
that
Mary Kennedy.
everyone, thank you for joining the end of the automatic EAD extension program. This new interim final rule published by the DHS today takes effect tomorrow, and it has significant implications for thousands of immigrants, especially those on H4 and G4 who depend on their EADs to work legally in the United States. We have with us our managing attorney, Ms. Kennedy. Ms. Kennedy will walk us through the background of the EAD extension policy, the categories it applied to, and what the new rule changes starting tomorrow. Ms. Kennedy, over to you.
Hello, everyone. Good evening. Thanks for joining. This is Mary from the Law Offices of Mary Kennedy. We are here understanding the calls that we had been getting from morning about the interim rule, especially on the EAD extensions. And we thought about doing this. We're very new, but again, all that matters for us to, be there present with you to handle the situation in a way that helps each one of us to understand and navigate and just trust that, it's a support system that's available and we'll do our best. Not wasting any much of our time. I see a lot more of questions that's coming up and everything. Sanjana, let's get into that.
Of course. So we have a couple of questions. Should I rush to file my renewal today before October 30th?
Yeah. So unfortunately, the rule has been, released in a way today morning saying that on October 30th and after, it's not going to be helping you to rely on the filing based on the receipt notices so that you can continue the 540 days. Sanjana, why don't we explain a very minimally about what happened and what is it? I know that is the change, major change, because even in a consultation in the morning today, people were not able to even understand what was the changes that was focused on. And then from October 30th, which is today, the interim rule is, effective.
Sure, Ms. Kennedy. So to talk about the automatic EAD extension program, it's a benefit under US law, under which certain individuals who file a timely renewal of their employment authorization document, they can continue working beyond the printed expiry date of their current EAD while the renewal is pending, as long as they are in an eligible category and they have met the receipt notice criteria. So now, anyone whose right to work depends solely on an EAD upon the announcement of this rule will have their employment authorization end once the current card expires. There's no extension. And among the audience of those who are watching today, this will particularly affect H4 holders and those with pending I-485s. So until this new rule, and if you were in one of the qualifying categories and you filed your I-765 renewal before your card expired, you could keep working for up to 540 days past the expiry date while USCIS processed the renewal.
Thank you. Thank you, Sanjana. That's a great explanation. And coming back to that, are we going with the question and answers because I see so many people have, had been waiting and then just elaborate and go back into the scenario for someone, who has been in this place right now, actually. So to clarify one more, so whoever has filed, you have applied for your EAD card. So those people, you don't have to be worried about it. Say, for example, even if you have sent out your filing. See, the only thing that you have to wait is when USCIS usually, for example, October 20th, you have posted your H4 EAD renewal. So then USCIS receives it on 21st or 22nd, but then you are yet to even receive the receipt notices, but you are in a much safer place because once you receive the receipt notice of your filing, you need to check it out to see that what it says on your, receipt notice of your filing. So if it says like even 29th, you're good enough, you can rely on that 540 days that has been said, and then you can continue to work based on that till you get your approval of the EAD card. This is something that you need to notice about it. And so let's go into the questions, Sanjana.
Thank you, Ms. Kennedy. So along those lines, we have a question. I have applied for extension a week back, and the payment has already been taken, but I have not received the receipt notice yet. Will there be any impact due to this new rule? I hope not. Please confirm.
Okay, and like you can go ahead with the answers and then let me go from there, Sanjana.
Sure, Ms. Kennedy. So as long as your application has been submitted to USCIS, you have the proof of delivery, and most importantly, you have the proof that your check got cleared before this announcement. Check getting cleared is basically an automatic confirmation that you are going to receive the receipt notice. And when you get that receipt notice, the receive date on that notice is going to be a date well before October 30th. So you should be good.
Sure, thank you. And then, yeah, let's go for the next one.
Is there any chance a court case will be filed to block this rule?
Yes, absolutely. Yes, there is definitely going to be, so the one thing that we notice here is it's an interim rule with an effective date of immediate effective date. So this shows that intention of the, DHS or the government to say that these H4 EADs, even we have noticed it in the prior period, where it could be blocked. As you can see that even in the short version of the memo, it has been clearly specified the earlier government when they brought, and there are a lot more of history that is related to this. All right, if you look into it, when the prior government, the Biden administration, has to leave their term, they made sure this has been made as a final rule, which means so that it makes it harder for the government, the current government, because this is anticipated. This cannot be allowed to be, having that 540 days. So that's one of the intention that was done towards this rule in particular. So keeping that in mind, so the interim rule was brought in with a lot more of, a surprise to anyone, even within the attorney community, to see that it has an implementation date of the same day that has been released. But at the same time, there are going to be a lawsuit and a TRO that has to happen. But again, this has been started as an interim rule. So the further it stands little more stronger than where, it could have been easily brought in with the relief of an, court intervention. What do you think about it, Sanjana?
Yes, Ms. Kennedy. Along those lines, we have one more query as well. Is it good to go for litigation if EAD is pending for more than a few months?
Yeah. Okay. So that's a very different question. So this we are talking about is about the interim rule, and then your question is related to earlier filed EAD, which has been pending. So in that case also, we have seen earlier to that, see this 540 days or even prior to the 540 days, there is a 180 days relief. That all happened to come to a place where you don't have to worry about the approval that's coming in, that you have to have the physical card of the EAD. That helps so many people. But even prior to that period, there were times where there was like not a very huge class action lawsuit that was, done, but even a minimum of, there are so many people joined together, like 5 of them, 10 of them, and they went to the court, and then they were able to, with the damage that happened, see some of them had to lose their job because of the timeline that was involved in the processing of the EADs, and then there were medical conditions where the insurance was not there, so people have to forego their medical conditions because they don't have a job, and related to that, there is no insurance that is there. So all these were considered by the court, and they were able to provide, request USCIS or force USCIS to adjudicate that EADs in a faster way. But that's a relief that we have to wait and see on that part of it. When we are talking about the interim rule, that is going to have its consequences. Definitely. See, if you look into that, like the Save Jobs, when they went for that H4 EAD last week, the court decided that they are not going to entertain that. That's also something to be reflecting on this interim rule to be released today on that part of it.
Thank you, Ms. Kennedy. We have another question. In my wife's case, her previous EAD expired in March 2025. I had applied for renewal in last year, December 2024, but the status still shows as case received. I'm due for my H-1B renewal in December. What will happen to her previous EAD renewal if I apply for one more EAD renewal along with my next H-1B filing? So while the previous EAD is still pending, applying for a new one.
Yeah, that's completely allowed, and you need to do that. I know, like, because this has nothing to do with the prior EAD that has been pending. That will be adjudicated on its own timeline of whatever has been waiting on. But definitely moving forward with your H1. See, I've been saying this for a very long time as well. Like whenever there is eligibility, because any extension that can be done has eligibility criteria of 180 days that can be applied for. Even in certain places, we have said even go prior to that when you file it as an amendment come extension. Is it right, Sanjana? We always advise, depending on your situation, if you're applying for it, apply a H4 along with the H4 EAD also, so that, like you are far ahead to not to wait to the last moment to get your approval of the H4 or the H4 EAD. So keep in mind it's a subjective answer, but you should definitely consider all those options before waiting to know that. So you have to apply for your H4 as well as parallelly H4 EAD based on your new H1B extension.
Thank you, Ms. Kennedy. I filed my wife's EAD renewal early this year, but I advised her not to go for or apply for any work until we get the approval. Any advice or suggestions or recommendations on this?
If it's an extension and you have applied for it based on the 540 rule, but as long as the I-94, that's very, very important, right? So sometimes we just rely on just filing an extension of the EAD alone. That's not the criteria. You have to have a valid I-94 that is also there on the H4 for you to even become eligible to get your, work continued based on the receipt. So if you do have both the qualification met, then you should be able to. The approval, what they mean is it's not the EAD card approval. It's more of an I-94 that's attached to the H4. Am I rightly understanding the question, Sanjana?
Yes. Mm-hmm.
Yeah, right. So the I-94 that matters, and we have given many other options how to get your I-94 if the H4 is also pending on parallel to the H4 EAD. But let's talk about it at the end of the call if we have some time about it.
EAD expires June 2026. Filing for extension is in progress. If new card with extended date arrives before June 2026, can the person continue working as is? What if processing is not complete by June 2026?
Yeah, I think we are coming back to the same answer to the same question, right? If you have an I-94 that's approved, and if it has been applied prior to October 30th in this scenario, then you become eligible to continue based on the receipt. Am I rightly understanding the question,
Yes.
Sanjana?
So, Ms. Neha, since you've not yet applied for your extension, the 540 days would not apply in your case.
Right. Then in that case, you have to wait for the approval of the H4 EAD card, and then only you can continue to work based on the H4 EAD card. That's right.
Could you please explain about concurrent H1 and H4 filings still being applicable?
Yeah, absolutely. That's correct. You can apply when you apply for the H1B, you can apply for the H4 and the H4 EAD. The only place that it changed is in January of 2025 when you applied for a premium processing. If you have applied it premium processing earlier to January 2025, then the USCIS was processing the H4 and the H4 EAD parallel to the H1B as well. So people were able to get the premium processing H1B approved, and then the H4 and the H4 EAD approved in a matter of 15 days. And if there is an RFE, a little extended time, but they stopped processing that. But at the same time, you can definitely file for a concurrent filing of your H4 and H4 EAD. We absolutely recommend anybody to do that to avoid with the delays that is also happening. And also one more concern in some companies, like the bigger companies, they don't apply the H4 and the H4 EAD. They just, ask you to find your own attorneys who can help you out. In that case, also, if they have filed the H4, H1B, for the primary, and then based on the receipt notice, you have to apply for the H4 and the H4 EAD as soon as possible. Do not wait for the approval. Most of the people that, even are, people who are well enough, well educated, well informed, they do miss out the point. And then they wait for, like if it's on a regular processing, or even if you go for a premium processing, that 15 days timeline is not needed. See, every day counts for you because you're in the line, waiting queue, waiting for the USCIS to approve. What matters to you is file it as soon as possible so that you are getting back to the line where it is, and so you can go from there. That's what I sincerely advise everyone.
Thank you, Ms. Kennedy. What is the impact for L2s?
So there's not, you can go ahead, Sanjana, but I will also add it up.
Sure. So L2s, they don't have to file an I-765. The very act of holding an L2 approval notice with that grants you work authorization. There's no concept of filing an EAD and getting an automatic extension. The L2 status itself authorizes you to work. Ms. Kennedy?
Yeah, that's correct. I know that's what it is. The I-94 that's attached to your L2 dependent will, like help you to continue your employment, as there's no EAD card that is associated with it. So you are good enough to continue your employment at this point of time.
Will this new rule also pave way for quicker EAD renewals as against the current SLA of approximately 12 months?
Oh, so you're waiting for 12 months? I was assuming like, 5 to 6 months, depending on, like all the other factors and the process, the processing centers and everything. 12 months is a longer period, but again, all the other discussions that's happening within the attorneys and the legal side of it is the intentional delay is going to be continued, and then it's going to be making it even more worse as the interim rule states, it clearly says it's to, put a stronghold of employment that is being assumed or carried away by the non-immigrants rather than the local people over here. So with that keeping in mind, I'll be surprised if they are going to process the approval sooner than not to drag or delay it.
Thank you, Ms. Kennedy. Is standalone H4 EAD eligible for premium? Unfortunately, it's not.
Right, like no, even along with the H1B, it's not allowed. So standalone, there's no premium processing for the H4s or the H4 EAD. That was a proposal long back, but I'm not expecting any way to help with this kind of a situation, and it's not going to come up as well.
If H4 EAD is not approved by I-94 expiration date, but if H1 gets approved in premium processing, can H4 go out of the country and get extended I-94 and continue working?
Earlier to that, it was all possible. Even we were advising people to go to, even using that automatic revalidation where you go to Mexico and then or Canada. There were people, like even a week before their expiry of the I-94, they had been traveling, and then they were coming with the valid I-94 based on the primary. They could have applied it on a premium processing. So the primary H1B could have approved it for 3 years. So based on that, they were able to travel, even not even going to your home country. like even just traveling and out of country and coming back with the visa revalidation of the countries of Mexico and Canada, they were able to do it. But right now, with this interim rule, how does it help, Sanjana? I'm also thinking through just having an I-94 is not going to help you to continue your H4 EAD based on the receipt notice. So right now, you have to have an approval of the EAD card in hand, which is very, very unfortunate. And I also felt in the morning today, I genuinely, when I did a podcast with the one of this one, I genuinely felt that in my heart that this is not fair for a H4 dependent. And most of all know the facts, even when we were looking at it, me and our team has been looking at the facts of people who had been, going through this H4, it's women. So being over this in this country without a valid work authorization and losing their identity, it's not just about work, it's so many things that's getting affected by this. And unfortunately, traveling and coming back and then getting a valid I-94 alone is not going to help, even though earlier point of time we had some scenarios where they were able to process the EADs far sooner, but that's a big question at this point of time.
Thank you, Ms. Kennedy. We filed my H-1B in premium along with my wife's H-4 and H-4 EAD on October 23rd. My credit card has not been debited yet. We didn't get the receipt notice yet. Are we good for automatic extension?
Oh, okay. It's a premium processing they mentioned,
Yes.
Sanjana. Right, so if it's a premium processing, like because I'm assuming all the other fees could have been paid by your employer, so you don't have the details of it because premium processing, you could have got your H-1B receipt notice by now. But again, with the H-4 and the H-4 EADs, it's very common to wait at least for 2 or 3 weeks to see that the receipt notice is getting received because H4 and the H4 EADs are considered as a normal processing. It doesn't have anything to do with the premium. But if I'm very sure if everything goes on well, you should be receiving a receipt notice, which shows that, as I said earlier in my conversation, when it says that the receipt notice for the H4 and the H4 EAD is received on 25th or 26th or what, no matter what, even 29th, you should make use of that 540 days, prior one that was helping you to be eligible to continue based on the receipt notice as long as you have an I-94 that's valid.
Yes, so Shalini, you should be good to go. A couple other similar questions as well. If the package is getting delivered on certain date, what will USCIS consider? It's always the date on which the package reaches USCIS. The check might get cleared later. The receipt notice might arrive, as Ms. Kennedy said, in 2 or 3 weeks' time, based on USCIS processing delays. But the receive date is always going to be the date on which USCIS receives the shipment from FedEx and they log it into their system, which is going to be the delivery date of the package.
Yeah, that's correct. Thank you, Sanjana. That's what it is. I know, like you should always look into the receipt notice that is going to be received in the coming weeks. But all that I'm saying is make sure you got it stamped, because it says the receive date and then the notice date. So the receive date always had been seen. It reaches the mailroom, even if you send the FedEx and they open it later on. But usually they have all those stamped in their facilities. So it will show that when you see that FedEx has been delivered, then it might not reflect it on that immediately, but receipt notice date. These are the dates, and make sure, like you get it properly, because also comes with that is unauthorized employment. In case somebody is relying, oh, I am all good to continue to work based on the receipt notice. My bigger concern was to see that people cannot be working unauthorized. I have incidents, people assume that, like, oh, this is what it is, that is what it, no. Moving forward, it has to be very, very clear. You cannot be working on the receipt notice unless it was received prior to October 30th, which is 29th.
Thank you, Ms. Kennedy. One person has brought up a very important point. In the USCIS article under categories eligible for automatic extension, they've mentioned for H4 EAD up to 540 days or expiration date on I-94, whichever is sooner. So this is something that you tell our clients all the time, right, Ms. Kennedy? If the I-94 is expiring prior to the end of the 540 days, that would constitute an end in work authorization, right?
That's correct. That's what we had been talking about it in multiple ways. So when all that we forget about it, and most of the time is, the I-94, the validity of the I-94 that has to be there to make use of that. So the whatever comes, the I-94 expiry or the 540 days, that's what you have to be relying on.
Got it. So I see a couple of repeated questions here. My H1 is approved. H4 and H4 EAD applied early this year. The H4 is not approved yet. It's outside the normal processing time. How long H4 EAD spouse can work in this case?
Can you repeat the question, Sanjana, or you can address it? Either way is fine.
Well, if the case is outside the normal processing time, it should be eligible for an expedite request, e-request. Um, we've seen that with our clients submitting either an e-request or calling USCIS once for a follow-up, that usually gets some action on the case. And this is only if it's outside normal processing time.
Oh, yeah, that's right. You have to compare it to see that. And how it works is like, say, for example, you applied it on, like March 1st of your you got the receipt notice as dated as March 1st. And then you see that USCIS, usually there is always a 30 days window. That is what they come up with the month, right? They don't go with the date. But when you see April, when you see that it's 30 days past, you definitely have to raise an e-request. And the most part of the time, practically speaking, with our experience of working with the USCIS, when you do an e-request, they are honoring that, and they definitely will help you out to process it. And unless there is a delay on any other reasoning, or they issue an RFE, or you should be able to send a e-request and ask them to look into the file, which helps mostly in most of the cases. In very limited cases, we go for the next step of contacting a congressman or trying to see how we can, they can all help that. But it's a very secondary. You are requested by USCIS, or you are set by USCIS. You need to wait once you send the e-request for 30 days. But usually we see a progress in a week or 2 weeks time period as well.
Up to how many days in advance can EAD extensions be applied?
It's usually 180 days prior to your expiry date of your card. And you should be eligible to apply for your EAD card. So that's how it works within the H1B period. If you have an H1 that's getting expired, and if it's an extension, then you should be able to go forward and apply for this extension. Along with that, be prepared to file your EH4 and the H4 EAD card as well.
So there's one question that we're getting quite often related to this. A couple of people have reached out to us stating that they have not yet met the 180-day requirement. They're still at like 200 or 190 days, and they plan on giving an attempt and filing it anyways. What are your thoughts on this, Ms. Kennedy?
So there are two things, when I have to consider this. I won't be surprised when earlier it was not a problem. I have seen people, like practically going ahead, and if they have an H1B that is filed as an amendment come extension, which means they can anytime file it, even though practically 180 days if you're asking for an extension. But there are many times USCIS considers the H1B approval continuity of extension, even if it's more than 180 days. So people used to apply it even with the 7 months period, and then apply for the H4 and the H4 EAD together. So there are two risks that is involved if we are going to advise you to do that. The first one is, if they don't accept it, it won't come as an immediate rejection, right? You need to wait for them to process that. They take anything that goes to the mailroom, as long as the check is getting cashed or now the credit card being accepted, they issue the receipt notice. But my concern will be after 5 months, after 6 months, if they come back and say you filed it in a window which is supposed to be within the 180 days, and you filed it, prior to that, my concern will be you will be losing. If they reject it at a later point of time, you're just going to be losing the 5 months period you had been relying and waiting on this EAD that is getting processed. I have not seen it in the prior period, but with everything going on crazy, I should ask you to follow the rules of 180 days. Within the 180 days, try your best to file it as soon as on the 180 days period. Like you just have everything ready. Don't go finding all those documents, like your pictures, that can even delay a week time. So be practical, have everything ready, and however you're planning to file your H-1B, start, just exactly within that window of the 180 days. So it helps even to get in line prior to so many people who are going to be waiting on that.
Thank you, Ms. Kennedy. And as you said, to reiterate, filing the application, having it rejected, that is one thing, but then having it accepted by USCIS, having it processed for 5 to 6 months, and then finally having them come back and state the application is not valid, there's a possibility of losing all that time. So thank you for bringing up that point, Ms. Kennedy.
Mhm.
We have quite a few questions here related to the shutdown and LCA filings. We are definitely going to address all of these. The questions that we didn't get time to answer, we're going to be replying to those over the chat right after the live is over. We'll take a couple
I can
more.
address a few, a few of them on that LCAs and, there's the 60 days grace period and, what could be the people's option, whether to go back to the, B2, B1 status or what's happening. And also we are planning on to continue this because one thing I see more and more as people, like even so, even in our office, we do a lot more. Even I had one person exclusively to address this from this January of 2025, just to take calls, addition to whatever our team was, understanding that we are there to support the community in any means possible. So keeping that in mind, you can expect that we are going to be having more and more sessions, or we'll come up with a plan where we'll have one particular day in a week where we will be available for you to address your questions and concerns. The team is very supportive. Always, I'm grateful for the team because waiting on a weekday evening, late in the evening, with all energy, whatever you have, I am always there. I don't get tired about immigration, but that's not the same I could expect the team. But we will come up with the different strategies and then spread it on to your friends, family who might get benefited out of it in any means possible. But coming back to this, Sanjana, we will definitely address those questions as you said, even in the YouTube. But also we will go a little bit on the what's happening on the H1B side with the shutdown. Where do you want to start?
Of course. So I'm seeing a question that's popping up in the comments a lot. If the government shutdown continues longer and they decide to file change of status to B2, will there be 100K when I file the change of status back from B2 to H1?
Yeah, right. Um, so the now the understanding is with the proclamation and the clarification that has been given and everything, it is whenever there is whatever the change of status within the US, right? It can be of any status you are already here. It shouldn't have that 100,000 to be paid for. It can be of an H4 status or like F1 status or anything else. So why does the B2 makes the difference as long as you continue to stay back within the country? So most likely it shouldn't be a problem. It shouldn't have the requirement if, say, for example, H1B to B2 has been done with the as a bridge petition, unless like this way they are going to bring up another policy memo or an interim rule to say that, oh, we can allow only the other status, not the B2 status. As of now, I would say that it's not applicable. 100,000 is not going to be, you are going to be asked to pay for it.
Thanks, Ms. Kennedy. I'm in my grace period until December 5th. The H1 transfer is blocked because of the shutdown and not being able to file LCA. Would USCIS allow H1 transfer without a certified LCA, considering it as an extraordinary circumstance?
So there are multiple situations that's happening. It's definitely a very, very subjective question. As I said, see here, even though we talk about so many different scenarios, as much as possible, we are giving a general answers. And then even before that, we could have said that. But I trust that you're all coming from an informed, intelligent, educated community. So you understand this is, like a very, very general answers that we are giving it. Coming back to that, there are multiple scenarios that is happening because it's almost like, 30 days and the people are really worried at the place where they have an offer in hand. They couldn't start their employment and then they are losing their offer if they don't, if they cannot have an H-1B being filed, and also changing back to an other status like B1, B2, if they cannot, they will not allow them to work. So it's a very, very subjective scenario. So filing an H-1B without an LCA is not, we cannot recommend. There are two things that can happen. One is USCIS will, later on, because the online system is allowing to be filed without an LCA because the mailroom is very different. We have not dealt with that because they are not going to be accepting it. All that they do is they have a checklist and they'll just reject this petition. But when it comes to the online, but the real-time concern is USCIS accepts it and then they take the payment on a regular basis. But if they come back and say that there's no LCA, but technically speaking, on the legal perspective, USCIS cannot process an H-1B without the LCA filed LCA, but they have given every indication, but not clear instructions till date what they are saying, it's going to be lenient enough for you and all those. How retroactively for a LCA that has not been filed after the shutdown getting cleared, USCIS is going to honor that is a $100 million question that we are facing. But in certain places, there are people, law firms who started filing and then seeing that how they are going to handle the situation we are not also recommending to do that as you will forego the like the filing fees if they say that refile again along with the proper LCA, but we'll excuse your time that happened between I-94 lapse expiry or the 60 days grace period, but refile an H-1B again with the proper LCA, or they will be able to continue this already accepted H-1B and then ask us to file an LCA and then attach it. It's a very, very unknown details at this point of time that we are in. But if you have an option, just don't leave the country because you are going to be subjective to the 100,000 no matter what, whatever matters. If you leave the country and it has to be filed as a new employment, you are going to be subject to that. So make use of that, take a chance, do and change your status if you are eligible for a H4. That's very well and good. Change yourself to the H4 status and then go back to your H1B after as on a premium processing after the shutdown gets cleared. If not, also try to go back to a B2 status rather than leaving the country and then trying to come back.
Thank you, Ms. Kennedy. So as one last add-on to that question, a couple of people are asking what would happen to the H4 and EAD applications if the H-1B primary petition is held up due to not being able to file the LCA. So the H-4 dependents would also have the delay to file excused because of the government shutdown, right, Ms. Kennedy?
Yeah, that's correct. That's a very good question. I don't know whoever wants to know about it. It's getting detailed going into it. It's not, and it's very interesting. I kind of like to talk about the scenarios and explain. That's very good. Even in one of the places where yesterday I was talking or guiding someone on a consultation call, I was trying to see that how the H4 and the H4 EAD could be saved. One of the reason, if they go back to the B2 along with their H1B, they are also foregoing the H4 and the H4 EAD in this scenario because once they convert themselves to the B2, it's the H4 and H4 EAD is not going to be valid. So when they file for the H1B change of status, that's again they are going to start the process. And now with this kind of a place, another 5 months, 6 months is going to happen. So for those kind of people, all that matters for you to just wait. I know waiting without 60 days gone by or your I-94 is getting expired. In so many scenarios, it's very, very stressful and people are getting very anxious about it. But I would say have a talk to a proper immigration attorney where you can definitely, like get some, in-depth details, go into subjective as much as possible, analyze the risk that's involved and take a chance. But as much as possible, preserve your H4 and the H4 EAD if you could do that.
Got it. One question that I don't think we've seen before, people who are working on 540D extension already, do they have to stop working until they get the EAD card?
No, whoever has been filed and they have an approved I-94, then in that case, as we were talking about it earlier, you can continue based on this 540 days. And all that matters is from October 30th, right? So you are good to, continue your employment.
Got it. We have quite a few questions here, and we'll definitely be providing our contact information for our law firm, all the different ways in which you can reach out to us. Our team will also be going over the live comments once again after the session, and we'll make sure that each and every one of these queries is addressed. I know there's a lot of them that we didn't get time for today, but we are sincerely grateful for everyone who has taken the time to attend this live and put forth your questions. We really understand that this is a very pressing matter, and we definitely want to do our best to be available to answer these queries. Ms. Kennedy, to wrap up the session, would you like to add any closing thoughts on how this may develop further, when we can expect updates?
Yeah, sure. Thank you. See, I always, like for me, supporting no matter what in any places where we are and matters a lot. So we will do our best even to reply to all those questions that has been raised. And then I speak Tamil. Most of you know about it. If you feel, like something as a parallel session after this, if your interest is, please feel free to say it in the comments as well, so that it makes it easier. I'm 100% okay in talk in both the languages. I hope I know better other languages as well. But please, feel free to put your comments, and then parallel to this, if you people feel that, it can also be there, I'm more than willing to do that, taking another day or time as well. As we also want this to be as a continued support where we want to provide as much as possible, legal information, because relying on so many other places, data's, and then coming back, and also more than that, just jeopardizing your status, assuming that, oh, I thought this is all okay to do this, and after that there is no way we are going to be reversing any of those damages. Even people who are so much into this misses out to renew your passport, continue to stay being here, and then don't know what to do after certain period of time. So please avoid all those, and we are always there to support. I said, I am here to unconditionally, I'm honestly saying that, to provide as much as of a legal support. So pass it on to people who genuinely needed some help, some advice, some thoughts. In the meanwhile, we'll reply to all your comments, questions as much as possible, and we'll also provide our contact information. We'll be there in certain scenarios, if you need any more guidance on that as well. And then we'll try our best to be, making it. We just started this today as a live session, as I was, going through how do we do that. So we'll be very frequent, provide as much as updates, and then we'll go from there. Looking forward for all your inputs, thoughts, and, be at a place where you're assured anything will come up with the relief on that. So don't overstress yourself more than anything else. As from a care and concern, I say this, things we can always sort it out, be hopeful on that. And so we are all there to support each other. Thank you so much, Sanjana, Aparjita, and all the others in the team who had been, so all that I said in the morning was like, I had multiple back-to-back consultation, but just told the team, we have to do this. Let's do it today. And we are all here, and we'll continue to do the, better work, better service. Thank you so much. I'll end it up with the Vanakkam, because that's my Nandri. It means thankful. That's it. Thankful for everyone being over there, taking your time. I hope it's helpful for all the others. Please pass it on. Thank you.
Thank you. Thank you, everyone, for joining. And we'll continue to keep you updated as more information becomes available. Thank you, everyone. Have a great evening. Thank you for attending.
Thank you. Thank you all.
Thank you all.